Hello, everyone. My name is Paige Murata, and on behalf of USLAW Network, we welcome you to this USLAW Remote Learn webinar. USLAW Remote is a series of virtual offerings ranging from our brand new podcast to roundtables and more. If you'd like to learn more about these offerings, I will post a link in the chat. Today's webinar topic is labor and employment changes in the first 100 days. Since this session is set up as a webinar, your microphone and camera are turned off, but you can use the Q&A feature to post any questions and comments, and our panelists will answer them as they come in. We do want this to be as interactive as possible, although it is set up as a webinar. Now I will turn it over to three of our member attorneys and allow them to introduce themselves.
Wonderful. Thank you, Paige. I am Julie Devine. I'm from Lashly and Baer in St. Louis, Missouri. And I am a labor and employment attorney. Thank you all for joining us. And I just wanted to reiterate Paige's comment that although this is a webinar, we really do want it to be interactive. So again, really welcome all of your questions and comments. And I'll turn over to Lisa to introduce herself.
Good afternoon, everyone. Thank you so much, Julie, and thank you everyone for attending today. I'm Lisa Zaccardelli. I'm a chair of our labor and employment group here at Hinckley Allen. I sit in the Hartford, Connecticut office. I may know some of you, and we're as Julie said, we want to make this as interactive as possible. It's set up as a webinar, but of course, questions and your real-time issues and looking for solutions. It's always helpful for a collaborative process as we're talking about the first 100 days. I'll now turn it over to my colleague, Jennifer Martinez.
Hi, everyone. I was about to say good morning, but I guess that's only on the West Coast. Jennifer Martinez here. I am a partner at Hanson Bridgett in our employer services section. I am also the firm's chief DEI officer and advise clients on DEI related issues specifically, which of course have come up a ton in the first 100 days.
Wonderful. Well, I think this is a great opportunity to talk to everyone. I don't know whether it feels like 100 years or 100 minutes that we're at 100 days. Sometimes it seems like it's gone quickly, and sometimes it feels like this has been a long period of time. But I think it's a nice opportunity for all of us to reflect and talk a little bit about where we are on some of these major labor and employment issues. I think, it's interesting geographically between, Lisa, Jennifer, and I. We've got kind of a West Coast and East Coast and a Midwest. I do think some of these topics, vary a little bit based on jurisdiction and what's going on. So those are some of the things that we can also explore, because I know those are challenges for everyone based on where you are. And I know that, a lot of the folks on this webinar have operations and employees in multiple different locations, which also adds to the challenges that we are facing. But, I think like Jennifer said, related to the diversity and equity issues, that's a major issue that I think all of us in the labor and employment field have really been addressing and answering questions and exploring in these last 100 days. And I think that might be a good spot for us to start. I will say that in my experience, and I want to throw it to the other panelists and also, again, encourage questions, but I think there's been a bit of a mix on how clients are responding to some of these issues. I think some of it depends on the geographic location. I think some of it depends on the sort of customers and employees and values and desires of the companies and how they want to address some of these issues, how they think their customers will respond. I think that's some of what has come down to it. I think some of it depends on a little bit on location. I think a lot of folks have taken a little bit of a wait and see response, that they haven't wanted to make any sort of drastic changes, I think, for a number of reasons. One is because they're not sure how the law will land. And I think that there's also some concerns about the pendulum, right? That the pendulum might be going in one way now, but might be moving in another direction, and the timing of that. So, I will kind of throw it to Lisa and Jennifer to say kind of big picture what you're seeing and what kind of questions you're answering for clients related to the diversity and equity and inclusion issues.
Sure. So I'll start. I think we have to, sort of take a step back and remember that this, we started here on January 20th with a flurry of executive orders that impact, what policies and procedures and how organizations, internally and externally are managing their labor and employment issues. Coupled with that, of course, was the tumult to whether it was the EEOC or the NLRB and the configurations of those and those agencies and boards. When you look at the two, what I call the two DEI executive orders, I think most clients, particularly as if you're a federal contractor or a private employer, are focused on how they, go about managing and understanding what the executive order is as it relates to their federal contractor requirements, where they are having to make certain representations. We know that the litigation landscape is still a bit unsettled as it relates to those affirmations that have to be made as it relates to federal grants or federal contracts. But separately, this sort of even though the executive order essentially dismantles affirmative action programs for women and minorities, a lot of companies are, hesitant to, essentially do that. They may not, so they've essentially decided to put those programs on pause. They may be, but they may have separate obligations under state statute. So for example, if you're in Massachusetts or Connecticut, you have pay equity laws that require the evaluation of information and response as it relates to race, sex, in some jurisdictions, ethnicity. And so even though the formal affirmative action plan documents and the collection of information in order to promulgate those plans may no longer be required, and those activities have been paused by companies, not maybe completely dismantled. To your comment, Julie, the approach of a pause and still sort of a wait and see. There are you may have state obligations that you still are having to comply with, and making sure and trying to nuance the messaging is probably, I think, one of the more challenging things that we are seeing and having to guide employers on. And I'd be interested in Jennifer's take on that in California. I'm sure you're focused, there's heightened focus on that issue as well. And how you are talking to employers and making recommendations to employers on those issues.
Yeah, and I'm so glad you brought up state nuances, Lisa, because that is crucial here, right? In California, for example, gender identity and gender expression are protected categories under our state anti-discrimination and harassment law. So I can see situations where employers might be confused on this direction from the federal government defining gender in one way and how that conflicts with state law. You still do have to comply with the state law requirements in California. I guess I think the other broader point that I'd like to make, and this applies, across the nation, but perhaps is heightened in states like California that have more employee protective laws, is this notion that kind of rolling back DEI programs is risk neutral, I think we've got to pick that apart a bit, right? If you think about when DEI as an official acronym, as an official set of initiatives and programs began, it was because we were finding a way to proactively preempt traditional discrimination claims, right? Is the reason we put a lot of those DEI programs in place. So rolling those programs back because of the risk of potential reverse discrimination claims, I think is a little bit misplaced, right? All you're doing is returning to that place where we had the risk of traditional discrimination claims that required implementation of those DEI programs. So it's not to say that you don't consider a rollback. The point is to consider that risk of traditional discrimination claims in the decision to roll back or how. The other point I guess I'd like to make on this litigation landscape, completely agree with Julie and Lisa that we are in uncharted territory. There has been no resolution on kind of the enforceability of some of these executive order provisions. Where we do have a little bit more clarity in the legal landscape, though, is the way DEI programs have been challenged in court. And that's come primarily in two different forms. Regular kind of employment claims that you're probably all familiar with, but also Section 1981 claims under federal civil rights law. Where those challenges have happened in courts, people that are opposing DEI have not been all that successful in courts. Now, we have had a lot of settlements, a lot of kind of dismissals of cases as moot once certain issues have been fixed. But where DEI has been challenged, it has mostly stood up to the challenge in court. Where it has not has usually been in one of those bad facts making bad law cases. So, for example, there's this case out of Pennsylvania involving some anti-racism training that was required for professors at Penn State University. They had a series of trainings called, the literal title of the trainings was "White Teachers Are a Problem." That's not okay to do now. It was not okay to do, 5 years ago before this current DEI backlash. But like I said, that would have always been the case. There's nothing special about what's happening now that would have said, oh, all of a sudden that training is a problem now, right? So that legal landscape, we do have a little bit more clarity that these programs do help us manage risk that has always existed. So I'll stop there.
Yeah, no, I think that's a great point, Jennifer. And I think the other thing that companies need to be looking at and obviously understanding, and then looking at your own policies and programs, both again, your external and your internal, your employee resource groups, your women's forums, many, organizations have these, your promotional practices. As Jennifer said, what's illegal under Title VII is still illegal. And I think if you take a step, if you look at the EEOC recently issued guidance on, what to know about DEI related discrimination, it specifically calls out those things which are exclusionary, like the example that you just gave, Jennifer. But it is a good idea, and we've been advising companies to do this. If you have things like employee resource groups, or you have forums or mentorships, are they excluding, to the extreme, to the sense that they are not, they don't act or appear in a way that is inclusive. And ultimately, there's not, as I say to clients all the time, diversity is not illegal. Diversity is legal. What is illegal is what has always been illegal under the law, under Title VII, which is exclusion based on race or gender. And so when you are looking at your programs and your promotional practices under the lens of these executive orders or the EEOC or Department of Justice guidance, you need to just be thinking about it like you always should be thinking about it, which is it in some way exclusionary based on race or gender? So I'll say, Julie, I'm sure you may have some clients that you've advised on these issues as well.
Yeah, no, I wanted to ask Lisa and Jennifer your thoughts on this, because I do have clients who have affinity groups, right? And they sort of say, well, they've never been exclusionary, but, you know, are they inclusive enough, right? And what does that mean? So is it enough to say this is open to everybody, right? Is trying to be more proactive to say we're having a women's lunch and everyone is welcome? You know, I've had some questions of, you know, we have a women's networking event, and that is for our, you know, our women executives or our women sales folks, or, you know, is that too exclusionary? Can we still call it that if we invite everybody, but can we still only invite women, right? So I would just be curious. I think those are some of the questions I'm getting, right? I don't think there's a yes or no, right? But when we're looking at, okay, make sure there's not barriers, make sure it's not exclusionary, sort of what does that look like on a practical level?
Yeah, so I think what's important here is that this actually might have changed in the past year. So there was a big Supreme Court case last year, Muldrow v. City of St. Louis. In our world, as employment attorneys, usually to bring a discrimination claim, there used to have to be some type of significant disadvantage that an employee had suffered for that claim to go forward. So on this issue of affinity groups, for example, prior to this case, if an affinity group simply met, maybe they were provided a meeting room, occasionally got lunch, that probably wasn't going to be enough of a significant disadvantage to qualify as discriminatory if that benefit wasn't given to other types of employee groups, right? After last year, and I think this is apart from the EEOC's recent guidance, this Muldrow v. City of St. Louis case, which involved PTO usage, or no, excuse me, which involved shift assignments. And the court basically said a plaintiff is no longer required to show significant disadvantage from an employer's action in order to qualify as discrimination. What I think that means relative to affinity groups is you better be providing similar things for each type of affinity group. So I'll give you an example at our law firm, right? The National Association of Women Lawyers, for instance, has these really great virtual leadership skills development programs for women lawyers at a certain level. This year, we opened the opportunity for that up to any lawyer of a certain level in the firm. Now, we did say this is a program put on by the National Association of Women Lawyers. The content will be curated, right, to the specific needs of women lawyers, but we at least made the ask of everyone. I think that's probably the direction you've got to head, right? Still okay to have the affinity group, still okay to run certain things through the affinity group, but maybe making a little bit more of an intentional effort to make clear that where there is a benefit. So not simply a meeting, right, or not simply a social event, but a substantive benefit like this leadership program, that it is open to everyone. And then I would also maybe do some homework, double checking that you are providing similar level of benefits, facilities, budget, etc., across the board for all affinity groups. Lisa?
Yeah, no, I agree. And you know, we had a client that had a women's forum, and that forum was, you know, they had particular groupings with it. They said it was, you know, obviously it was open to all, but they invited, you know, principally women speakers to speak about women issues. But they also had a concept of like a mentorship program within that. And I think exactly, you know, to your point, Jennifer, there's a benefit there, right? And that is sort of is the issue, because the benefit really was around women. And I think that is where that could be problematic. So the solution has really been ultimately not to have mentorships which exclude you know men, that they have the mentorship concept, again inviting all and including participation, will include men if they're going to continue with the mentorship component. And again, the mentorship component is designed to help promote, provide counsel whether that's substantive, arguably it could be. And so I think that that's, exactly where that they're nuanced issues, but I think the risk is not being too exclusionary is likely to, you're likely to have to run into trouble. So yeah, I think that's a great point. And, I guess I'd also be interested in, clients that, you might have, that may have sponsorships. I guess that's sort of akin to what you were talking about, Jennifer, but where they offer, diversity training scholarships, right? Where they're looking for diverse candidates. And there's a scholarship component, tied to those individuals getting for housing or access so that they can come and work for the employer. I think those two have to be looked at and have to be ensure that they're open to all, right? Not only what might be common for a diversity scholarship, that you are looking obviously to encourage persons in protected classes to apply. So I'd be interested in anyone's comments on that as well.
Yeah, I think this is where kind of my opening comment comes in, right? So yes, we are seeing a lot of action related to DEI in this first 100 days, but this really kicked off with that big Supreme Court decision in the summer of 2023, Students for Fair Admission v. Harvard, right? And why that decision is relevant to Lisa's point just now is in that decision, which again, to be clear, limited to the education context, distinctly does not apply to Title VII. But Justice Roberts had this section of the opinion where he said, look, even schools are allowed to make admissions decisions based on racialized experiences, just as long as they're not making the decision on race itself. Now, as a practical matter, what he meant is in that college essay that all of us can think back to, someone is allowed to talk about how, for example, their gender presented adversity and that all the accomplishments that they've achieved should be read in light of that adversity, right? Or with race, for example. Justice Roberts said, A-okay, you're allowed to make an admissions decision based on that, which race is sort of intertwined with, as long as the decision isn't because of race itself. So where I've seen a lot of companies pivot that have these pipeline programs, fellowships, diversity, right? They have those programs because there's a real lack of diversity problem in the industry, in the particular profession, right? We saw a lot of law firms were targeted. We have similar problems with diversity, right? So the purpose of those programs is still really important to guard against the types of traditional discrimination cases that are always going to arise. Where I have seen companies tweak those programs is bringing in this Justice Roberts workaround, right? So instead of simply saying these groups of people are eligible for this program, maybe they've added an essay requirement, a statement of interest type of requirement, where someone says, the prompt is to be eligible for this program, please tell us how you have worked to increase diversity in your community or in your school or in a prior profession. Please tell us how you, or I have a lot of healthcare clients, for example. So they have programs designed to bring more diverse doctors to serve diverse communities. So their prompt may change in that statement of interest requirement to tell us the work you have done to serve, for example, immigrant communities or to serve Spanish-speaking communities. And again, open to everyone, but you're making the actual decision based on the service of these communities. So still sort of honoring the purpose of the program, but making sure you're staying on the right side of risk for how the legal landscape has shaken out now. And Julie, let me stop in case you want to add something too.
No, I guess I had a related question that I wanted to throw out to this panel. I think some of what we are, I think in the realm of this has always sort of been illegal, any strict numerical requirements or, I think we've always known that you're always hiring the most qualified person. You're not considering race when you are making those hiring decisions. I would argue that hasn't changed, but I know in the hiring realm, there a lot of companies had, made efforts to sort of require diverse slates of candidates, right? And there were some of those things that I think were a little bit more numerical. Like we are going to sort of require a more diverse slate. We're going to interview a more diverse group. There are requirements for that, and I think a lot of companies are having some concerns about numerical requirements. So I think some of that is a little bit of a pivot of we want to, we want a wide range of people applying. We want to interview a wide range. But I just was curious, Lisa and Jennifer, your kind of thoughts on some of those hiring processes and what tweaks or changes you think need to be made on some of those.
Yeah, and I think we saw the EEOC in targeting law firms, right? One of the things that they were going after in these law firms that they sent these demand letters to was something called Mansfield certification. So for folks that don't have a company or a firm that's participating, Mansfield certification is a program run by this organization called Diversity Lab. Mansfield refers to Arabella Mansfield, who's the first woman to be barred in the country. But essentially, there's a set of standards. Some of them are related to transparency and processes and job descriptions, et cetera. But a lot of it, to Julie's question, is, have you considered a diverse slate of candidates for certain leadership positions, right? And yes, Mansfield does put a percentage on it. That's what the EEOC was taking issue with. To be clear, Mansfield and other similar programs don't require you to do that. They don't require you to hire certain number of diverse candidates. It's a accountability metric to say, have you considered at least this percentage? Where they got that from actually dates further back to the NFL, in fact, so something called the Rooney Rule. So the NFL realizing that while something like 80+% of the league was Black players, the majority of head coach positions were held by white coaches, oftentimes who had never actually played, right? And in fact, the number of Black coaches was super minimal given their representation in the league. So the NFL starts the Rooney Rule, says for head coach, and I believe coordinator positions, you have to have at least 2 candidates of color in the final interview round, right? They had an even more specific number rather than a percentage. Interestingly, the NFL has had some problems in enforcement, right? Because teams started to treat that as a ceiling, not a floor. And so they would do these kind of check the box interviews. They were sued last year by a head coach who Bill Belichick, incidentally enough, sorry to pick on our East Coast folks, our Patriot fans, Bill Belichick blew it. He accidentally texted the wrong person. He thought he was texting a different coach. He texted the coach a Black coach who thought he was getting interviewed, basically revealing that the decision had already been made and this interview was a check in the box to comply with the Rooney Rule. So there are problems in implementation regardless, right? I guess why I'm bringing that up is that I think that that's where, on Julie's question, the majority of issues come is on implementation. It's not necessarily the rule itself, right? So if you're doing Mansfield, it's not to say check the box that you had a diverse slate of candidates. It's when you're in the middle of a process and you realize, hey, we're not hitting that 30% mark. You're not horse trading, right, to get people in and out. You're going back to look at the process. Where in our process are we perhaps structural bias, implicit bias is not allowing a lot of diverse candidates in. And let's fix that process piece. It's not simply getting bodies in seats so that you can meet a percentage. But again, that's an implementation problem. Thoughtfulness of implementation, intentionality, not necessarily the rule itself, which I think is an important distinction to make. Lisa?
So, and I agree that's an important distinction to make, but I do think educating clients on that and making sure that, people understand that difference and understand that they do need to go back and look at their processes. So just like, I'm sure you've been looking at it, we've been all looking at it, advising clients on, what are their promotional practices? How are they implementing those promotional practices? What are their, what is on their website? What are the groups that the way in which they're looking and how are they going about hiring and looking for hiring and qualified applicants and candidates? It is making sure that they understand that difference, right? Looking at it's the process point, not saying, okay, we're trying to get to this target, because the target, the quote, however you want to characterize it, that's where it can become an issue. And if you're, and if you're in states like where we practice, Massachusetts, Rhode Island, Connecticut, California, we're kind of ground zero where these things are being really scrutinized and looked at. And I just think it's really critical that if you haven't really sort of scrutinized those practices, those processes, that you really do so, and you do so pretty quickly, because we are 100 days in, and all you need is one disgruntled individual to complain to the EEOC or the government. And if you work for a large company or publicly traded company, might try to go right to the Department of Justice. Trying to correct it in real time is not going to be the solution. So I absolutely agree with Jennifer on that. One thing I think we might want to so we've talked a lot about, and I think I'd be interested in both Julie and Jennifer's thinking on, like, do we have any predictions, right? Or is it in terms of what we see still coming down the proverbial administration pike? Because just the other day they issued, I think last week, the executive order on disparate impact, and that theory, and the EEOC guidance on there's no reverse discrimination, and so I'd be interested in both of your thoughts on what you have been thinking about in terms of where next the administration is going to turn, and then we can talk about some other topics.
Yeah, one thing that I'm seeing more as a trend as this issue about equal access despite college education. So looking at what jobs require college and why, that seems to be a sort of, I won't say new, but I think, a trend that I'm continuing to see. And so I think really looking at job requirements, and I will say with a lot of clients, they've just always had a college requirement for certain jobs or certain promotions. I do think that's going to be an increased area to really look at, and seems to be increasingly an area of interest. I will also say, coming from Missouri, I would say at least half of my discrimination and harassment cases are based on maybe whether it's a white male or whether it's a male, or whatever it is, there is a lot of litigation from people who believe that they have been discriminated against because they are white or because they are a man. And so I don't know if that trend, that's the state law based in Missouri, but I could imagine that if your jurisdictions are not seeing that will continue. And I will say that, I have been in depositions where they are cross-examining the HR department saying, your evaluation has a requirement about how diverse your team is, explain that. And so I think, fortunately, when I was in that deposition, that HR director was able to explain it in a way that did not appear to be exclusionary or discriminatory. But I think to be ready, that if they are not already, I do think that litigation will either increase or begin in jurisdictions that haven't seen it as much, and kind of being ready to arm yourself on how are we defending our practices when those issues come up.
Yeah, and on that point of so-called kind of reverse discrimination cases, meaning cases where the plaintiff is in a majority group, whether that's male, gender, white, race, or straight people for LGBTQ discrimination, right? There's actually a Supreme Court case that probably, my prediction is it'll be heard this term, Ames v. Ohio Department of Youth Services. This case involved a woman who was alleging straight woman who was alleging sexual orientation-based discrimination. discrimination. And the reason I think we'll see a decision from the court on this is there is a circuit split, right? In some circuits, reverse discrimination case plaintiffs have to show some additional background circumstances that show the unusual case of reverse discrimination is happening here, right? They have kind of a different burden than traditional discrimination plaintiffs. So that's going to go up to the Supreme Court. My gut is that the court will disavow that background circumstances doctrine, that they'll say whether it's reverse discrimination or traditional discrimination, the plaintiff has to show the same burden. I think that's the likely prediction from the court. My other prediction, though, is that I think a lot of the challenges to DEI programs, a lot of the challenges by so-called reverse discrimination plaintiffs, what I worry is we are lowering the overall bar for what constitutes harassment or discrimination, right? So there's the Muldrow v. City of St. Louis case that I mentioned last year from the Supreme Court. There's that Ames decision on reverse discrimination. I think we'll hear this term. I think we'll also hear this term a case from the Fifth Circuit, Hamilton v. Dallas County, which also is lowering the potential bar, right? In that particular case, which involved PTO usage, the Fifth Circuit held that the plaintiff is not even required to show an employer decision to base a discrimination claim on. So all of these cases involve people challenging DEI or coming from the majority group and challenging discrimination. And in the courts where they've been heard, which are mostly conservative-leaning courts, the bar has been lowered. If we go back to who set the bar, it was mostly conservative-leaning justices who put in place those higher bars for traditional discrimination type plaintiffs. So now we're lowering the bar for everyone to allow reverse discrimination plaintiffs to get in. My prediction is that maybe not this year, but next year, the plaintiff's bar is going to take advantage of that lowering of the bar, and I think we will see an even greater increase in the regular types of discrimination and harassment cases that we're all used to because that bar has been lowered so significantly.
So,
Lisa, you got to give us your prediction as well.
It just seems to change every day. I think that there is going to be a sort of continued review of private employers and companies and their practices and more litigation. I think that the Department of Justice is going to actively start looking at, they've sort of hit the institutions have been, the target. They're going to now focus their efforts on, larger corporations, probably banking, retail, looking to see whether or not they are, quote, compliant with these executive orders. That's what I think there is going to be a lot of activity that comes out of the Department of Justice as it relates to enforcement. So I was going to sort of turn now to our other, sort of major topic, of course, that's come out of the administration, which is immigration. I know from our perspective on our clients, that a lot of clients have lots of concerns about how to potentially deal with an ICE raid or audit, and lots of employers have put in place policies that try to at least provide guardrails for their employees on how to respond, so that they are both not obstructing justice, but at the same time understanding what not just the employees' rights are, but the employer's obligations to employees. I'd certainly be interested in, Julie and Jennifer's, discussions with their clients on how they've tackled where if you've had employers that have been the subject of a judicial or administrative warrant, and how that has been acted on, and what your clients are doing as it relates to their employee population in these times. So
Julie, go ahead, because I have a feeling California is the literal Wild West here, and we're maybe a little
Yeah.
different. So please go ahead, probably
Yeah,
answer for the majority of the country.
So I will start to say that, you know, what I have done for clients a lot is sort of working with them to prepare the plan of what are we going to do if ICE comes. Do we know the difference between an administrative versus a judicial warrant? We're sort of learning that. We're talking about policies. Again, we're balancing and making sure we're not obstructing justice. You know, I will say, just as a practical matter, my clients have not you know, where I am, you know, have not really seen a lot, where I'm not getting calls at 4 o'clock in the afternoon that ICE is here and this is, you know, we've got lots of plans, but we haven't seen that. Some of the enforcement or some of the that I've seen is a little bit, I wouldn't say random, but it's not, it doesn't appear to be this coordinated effort. Sometimes I think it might be someone reported someone and so they came, but it doesn't appear to be this, at least in my area, this sort of, you know, whether that increases or changes, I don't know. But I know a lot of, I think the initial things we were doing were all about, what are our plans in place? You know, what do we do? Do we know what the warrants look like? Do we know what our legal obligations are? I think now I'm starting to work a little more with clients about, let's clean up our I-9s. We need to do some internal audits. Do we have training about what we need? Do we know, you know, if there's no match letters, do we know what we're doing? Do we have some systems in place? And sort of looking a little bit deeper, I think, on this issue. And again, I think it might be geographically kind of what my clients are seeing or otherwise, but we're also looking a little bit with independent contractors. I think that there has been, I think there has been some concern, right? That people say, oh, well, I'm fine because these are independent contractors and they are employed by a sub. But I think there could be a little bit of risk there, that if you know that your subcontractor is not checking I-9s correctly, or that you are employing folks who might not be eligible to work in the US, that you might need to take some steps to address those things. So those are some of, I think what I've seen in my practice is pivoting from the what do we necessarily do when ICE knocks on the door to what does our paperwork look like, and you know, are we in good shape should there be an audit?
Now, like I said, the Wild West. So I think, you know, California is a sanctuary state at the state level. There's also several cities in California that are sanctuary cities. If you've got clients that are also in sanctuary states, or even in a non-sanctuary state, but a sanctuary city within a state, right? This advice might apply to you even if there aren't specific laws in place. So under California's sanctuary state law, there's a couple nuances, right? First, it prohibits any form of law enforcement officer from assisting or cooperating voluntarily with ICE investigation and enforcement activities. So, for example, I've got several public agency transportation related clients. They often employ their own law enforcement officers directly. If you've got clients like that, better make sure that their law enforcement arm knows about that prohibition on assisting ICE. But probably more relevant, in California, we have a law called the California Immigrant Workers Protection Act that specifically prohibits both public and private employers from giving voluntary consent to any law enforcement or immigration enforcement agency, either to search or enter non-public areas of the workplace, or to turn over personnel records, again, without a warrant. So prohibiting voluntary consent. By all means, if they have a judicial warrant, the company has to comply. An administrative warrant, arguably this Immigrant Workers Protection Act would prohibit, for example, if the employee is behind in a non-public area of the workplace, not allowing ICE to enter that area to physically pick up the employee, not telling them even that the employee is present on the premises. So if you've got clients in California, by all means, make sure you're getting that California specific advice. There are statutory fines for failing to prohibit the voluntary consent. And I think this is where the employee training, as both Julie and Lisa have mentioned, is very, very key, right? What constitutes consent to enter into a non-public area is a really fine line. Even saying like, no, I don't mind if you go there can constitute. So being sure that your employees are aware of those lines. And also, I think Julie mentioned this, what the actual documents look like, right? What an administrative warrant looks like versus a judicial warrant is going to be really key. And if you've got sanctuary cities in your jurisdiction, I would make sure you're getting advice on what those particular sanctuary rules require of employers.
So Jennifer, it might be good just to educate the audience on the difference between a judicial warrant and an administrative warrant, and maybe we could do that. So that
Yeah. So judicial warrant, I think the easiest thing to remember is it's going to be from a court, right? That's the big difference. It's going to say district court, it's going to say superior court, or however the state courts are named in your jurisdiction, and it's going to be signed by an actual judge, right? Some other kind of nuances, both for judicial and administrative warrants, is they better describe the place to be searched with particularity. If it's an arrest warrant, they better name the person individually, right? It's not enough for a warrant to simply say all undocumented people on the premises. An administrative warrant is usually from the Department of Homeland Security or from some other federal agency, right? USCIS, CBP, etc. It's not from an actual court, and it can sometimes be signed by an immigration officer rather than a judge. Those administrative warrants are usually only for the detention of a person, right? They don't give the law enforcement agency the authority to enter any non-public area. They have to have consent for that. So they come in your lobby with an administrative warrant for an employee. They can wait in the lobby in case the employee comes out. They're not allowed to enter into the non-public areas of the workplace simply because they've got the administrative warrant. That's the big distinction, I think, between judicial and administrative. Julie, please jump in if I'm getting anything wrong here.
No, that's what we've been looking at. And some of it I think is just, court and judge, right? Like, that we've been really focusing on, that there are some nuances there, but there are, and I think we've even, sort of just shown examples so people can kind of see what this actually looks like. I would be curious, Jennifer, in my experience, some employers have said, or I have sort of heard through the grapevine, that people are coming with administrative warrants and still kind of getting what they want, right? That sort of in the stress of the moment and in the, someone is coming and I don't know, sort of your experience or from clients, like, is it working when you say, no, this isn't a judicial warrant and leave, whether that's been successful or any experience there?
Yeah, I think great question. For those of you that have clients in the healthcare space, what I think we've also seen is immigration enforcement coming on the premises to look for a particular client, right? And there you've got the whole added layer of HIPAA and privacy requirements. Even simply confirming that you're treating a particular person can be a violation of HIPAA, right? So we do very specific training on that very issue, Julie, right? Is knowing how to stay calm, how to manage your response, having a very specific protocol so that in an ideal world, if there are immigration authorities on premises, though frankly, this could be for any law enforcement authority, that you have one person, and that way not everyone feels compelled to be the spokesperson, right? Which is where a lot of those little miscommunications could go wrong. What I'll say, that's something that people are often forgetting about this issue too, is you better have a plan for managing employee reactions after the interaction, right? Even if ICE leaves peacefully, right? If you say, nope, it's only an administrative warrant, not a judicial warrant, it can be traumatic for a lot of employees, even if they're not the ones targeted. So have a plan in place for how you're responding to that trauma reaction, whether it's pointing them to an EAP program, knowing where the nuances are for if the complaint about their reaction rises to the level of a disability you might need to inquire into, whether you need to give time off under the Family Medical Leave Act for that stress related reaction, right? Have a plan for that as well. So not just at the front end, what to do if ICE comes to the workplace, but also on the back end, how to manage when they do. What I'll say is, yes, the training is kind of nuanced to this is how it might go wrong. These are tactics ICE might use to get you to consent, to sort of make you panic, and then accidentally let them go into somewhere that they're not allowed to. We're trying to do all that. It's never going to be perfect in the situation, right? Everyone always gets nervous, has anxiety when they have interactions with law enforcement. And so I think that's a great point, Julie. It is very easy for these things to go wrong. All the more reason to have a particular spokesperson and a protocol.
Yeah, and just following up on all of those points, I think that, again, going back to the training is really, really key. Not just having the protocol policy, but making sure not that your managers and you may do some training to all of your employees so they just understand again that something could happen. To your point, Jennifer, trying to in some way, I think, mitigate what could be, could be a traumatic response. I also think it's important if you don't have someone who you can go to. I wouldn't be going to your corporate counsel to determine what the contents of the warrant says and what kind of warrant and what that allows for. You should have it, as part of your protocol, a counsel who either is white collar counsel, criminal defense counsel, individuals who are familiar with these types of warrants and executions and what's from a criminal perspective. That is essentially how you need to be looking at this. And I know that we had a situation for a client where he was coming. We had some concerns that the individual was leaving the United States. He was a naturalized U.S. citizen, but there was some concerns about him coming back into the country. And we sort of lined up a cause of action where we could go into court if necessary. The individual was detained coming back into the U.S. And it's in part because, whatever the reason, there was some things out there that, speeches that he had given, that we had a concern, he had a concern, might make it difficult for him to re-enter the country. So the point of all of that is don't wait until until the law enforcement or ICE or another body that has been empowered by ICE to come to the premises. If you have some concerns or you think there's some potential, there are some risks, you need to put these processes in place, and training is really critical. Your managers need to understand how to appropriately react and making sure you have that point person.
And I think if you have H-1B visa employees
Yes.
too, to Lisa's point kind of about the unpredictability, right? If those folks are traveling outside of the country for work, I would be proactive and have a plan for what happens if they encounter trouble when they're trying to come back into the country as well. I guess last reminder too, remember that both national origin and alienage and citizenship are protected categories under Title VII. So if you're hearing all this stuff about ICE and your solution is, well, we just won't hire anyone that's not a U.S. citizen, that's an illegal policy under Title VII, right? Can't discriminate on the basis of national origin or alienage or citizenship. So just be careful when you're trying to be too proactive in your protection measures that you're not crossing that line as well.
So I see we only have a couple more minutes. I thought we'd just quickly talk about where we are at the NLRB. And the FTC non-compete regulation, which was not formally promulgated because of the injunction, where we think those things kind of stand right now. Of course, the NLRB, the appellate court did allow for the one of the board members to be placed back on the board. That case, I'm sure, is going up to the Supreme Court. But the NLRB is currently constituted so that it could hear cases. So I'd be interested in, again, I know we only have a couple more minutes, but we probably should just touch upon where we see the NLRB going and the FTC. And Julie or Jennifer, I'll open it up to both of you.
Yeah, I mean, I'll quickly, for now, I don't know about a prediction, but things seem to be just quiet, right? There's kind of we're kind of on hold. It seems to be for a lot of my matters that would involve the NLRB. We're just kind of not hearing a lot. I think the FTC issue is a little bit interesting because if you're reading the tea leaves, there still does seem to be some concern about unreasonable non-competes or overbroad non-competes. So I think this idea that everything is improper, I think that's one thing, and I don't know that the Biden rule is going to come in place, but it has been interesting to see that at least there has been some acknowledgement that some non-competes might be overbroad or concerning. So, what's the prediction? I don't know, but I think, maybe there's a little bit of room there that we might see some restrictions be starting to come in place about the scope of non-competes.
Yeah, I would agree. I mean, I think if you look at who was the FTC chairman has, publicly said that he did not think that the Biden rule, should go forward. And so, but to your point, I do think that there is a recognition that non-competes or documents that act like non-competes, unnecessarily or unfairly restrict individuals who maybe aren't at that level where they would have, access to confidential information, or your concerns about customers, those really, more protectable interests. And so I do think that there is likely to be something that limits. And I know, Jennifer, you live in California, so you're another land of the Wild West, but those agreements are still enforceable in most of the jurisdictions that we operate in, but I do think that there's going to be some restrictions on those types of agreements, more maybe closer or akin to what's whether it's exempt, you'll only ask to exempt employees, or certain or putting wage thresholds in. But I do think that there's going to be that. So.
And I guess last little closing comment here. We didn't plan this to be this kind of fluffy closing comment, but this is actually the value of a network like USLAW, right? That especially on the issue of restrictive covenants, you do need state-specific guidance. As Lisa alluded to, California, we haven't had this problem. We have long banned non-competes unless they're in very narrowly tailored situations, usually related to the sale or the dissolution of a business, right? And even then, there's specific nuances to get the enforceability right. The other piece to keep in mind is it's not just the state-specific law, right? A Nevada company, for example, can't say, well, we're in Nevada. It doesn't matter that our employees are in California. They're subject to a non-compete. California doesn't allow that either, right? Or tries to disrupt that process. So please get state-specific counsel on any issue of non-compete until we do have that resolution at the federal level.
Great. So I don't see any questions in the Q&A, so.
Yeah, I think our time is probably up, but all three of us are certainly available for questions if there's anything. I think there are going to be there will be a lot of questions, right? This is the first 100 days, but I certainly think that there are going to be continued changes in these areas. So we are certainly available to answer any of those questions, and we appreciate you joining us today, and hopefully it was useful to everybody.
Great. Thanks so much.
Thank you.
Great. Well, thank you, Julie, Jennifer, and Lisa, and thank you to everyone for participating in today's webinar. If you wish to participate in any future roundtables or webinars, please take a look at the message I've just posted in the chat. In addition, a full schedule of events can be found on the US Law Network website. Thank you.